They said he's going to be removed without due process. So they held an evidentiary hearing and they ordered the government to, if he's released from Tennessee, you have to send him back to Maryland and give him written notice that he's got 72 hours before you do anything so that he can assert claims of credible fear, which we're going to read about from his first attempt at claiming credible fear. So then on August 22nd, the government noticed Kilmar's lawyers that it was going to remove Kilmar to Uganda. It's a nice place over there, though it provided no such notice as required to the petitioner. And we saw the notice. We read it in the email. They're going to say that it didn't comply with the notice because it's outside of the 72 hours would be my guess. But I think that the Trump DOJ probably looked into that and said that you can't count, that counts. Like you can count the judge excluded the weekends, but the DOJ is saying we're counting the weekends, like that counts. And now the government has, without forewarning, it's not true. They did send him a total warning. They've taken him into ICE detention based on notice of removal to Uganda without providing him an opportunity to be heard on his expressed fears of persecution or torture in that country. So they say the court has jurisdiction to hear this. And Kilmar is a citizen and native of El Salvador. He resides in Maryland, illegally in our country. He's married to a U.S. citizen wife and has a minor U.S. citizen child. Now, recently at a hearing on July 10th, in Zenas' court, a high-ranking ICE officer testified under oath that ICE does not begin working on determining a country for third-party removal, or even indeed whether ICE would try to effectuate third country removal until a non-citizen is detained by ICE. Okay, so in other words, you arrest first and then decide the country after. Here, they picked Uganda first and then went and arrested him. So they say this is false.